Good morning. I'm really happy to be with you again today. I wasn't with some of you yesterday, as Lizzie said, because of technology. I didn't know that. It's a good thing I didn't know that, or I would have probably just totally freaked out. I kind of realized it when no one was in the room here with me. I really thought maybe there was a fire drill and I was going to burn in the building, but I was going down with the ship. So when you see, if you happen to see the recorded one and I have kind of a weird look on my face in the middle, you'll know what that's about. But we are, as Lizzie said, very pleased to have you here with us today. And before I start my presentation, I'd just like to remind you of what things we're going to be covering with you today with excellent presenters, I hope. Resolving common audit findings will be one of our most experienced certified public accountants in the auditor's office, Suzanne Elliott. And then Diane Allison, whom many of you have heard communicate. Diane's a great teacher. We'll be talking about effectively communicating financial information. Then Angela Heath, who's a lawyer who works with me and who has become our resident expert in the American Rescue Plan, is going to update you on some of the changes that the Department of Treasury made on January 6th to the plan. And we think this is important because it will give you a great sense of where your communities can go in the coming months in regard to these monies that are really one-time monies and should be a great benefit to the state. That said, let's talk. What I want to talk about today are what we call among ourselves the hot topics that we've been dealing with. We answered last year about 600 questions from many of you, and we don't resent those questions. We're glad that we got those questions, and we hope that we have helped clarify some situations. We always base our answers, as I've said many times, on what the Attorney General has said and what the courts say and what the common practices are. So that said, we kind of picked out some hot topics for today for us to discuss. The first one is open meetings. And the reason that I wanted to talk about open meetings with you, and before I begin talking about it, let me say this to you. What I'd like is, and I'll pause after I finish talking about open meetings and some of the questions that we've been getting, is I want to pause there and allow you to ask any questions that you might have on open meetings. I'm going to talk about open meetings, public records, the Local Government Budget Act, fiduciary responsibilities, reporting responsibilities under the Audit Law, some issues with cooperative endeavors, fiscal administration issues, and surplus property. If you're exhausted, I understand. So sit back and act like you're sitting in the passenger seat of my car and we're friends talking about issues that come across to you, I know, on a daily basis probably. The open meetings law, what our most questions are on notice and agenda and who can talk. Notice has to be given in can be given in various ways. And, I like to make sure you know that because otherwise you think, if I missed putting it in the paper or I missed posting it or I missed posting it on at where the meeting is or where the principal place of business, then I've missed. No, you can post, it's an or in the law. The or is you can post it in one of those three places, but you must post it on your website if you have a website. The other issue that we have on open meetings, another very important issue that we have is the whole, I'm turning to it here in my book, sorry, is the whole issue of the agenda and who controls the agenda. The agenda of any open meeting in Louisiana is controlled by the head of the public entity. That might be the mayor in a Lawson Act. It might be the head of the fire district, the head of the drainage district. That's the person who controls it. But here's a very important point, that even though that person controls it, it doesn't mean you can't get another item on the agenda. You can if there is a unanimous vote of the group, the Board of Aldermen or whomever. So I want to make sure you know that. The other thing is we get questions. Yesterday I had a question. Said, Jenifer, I got a lady who wants to talk. She's called us and said she wants to talk. But I got to tell you, she's a bit disruptive when she comes. Can I deny her for speaking? Listen to me. Answer, no. Open meetings and public records emanate from our Constitution. So open meeting means that the public has a right to know what's going to be discussed and participate in those discussions. So the lady can't be denied a right to speak. However, you can decide prior to that lady coming, and I highly recommend it, that you have policies as to how it goes when public speaks. Policies like you'll be allowed to speak for 5 minutes or 2 minutes, and then we'll move to the next person. You know, we ask that you not be disruptive. We ask that you go to a microphone. All of those policies should be developed and passed by the particular board. Now, if you have trouble with those policies, if you call us, we're happy to talk to you about it. If you call your neighboring town or district, I know lots of people have those policies. My friend Karen White at the Louisiana Municipal Association is very familiar with those policies. Now, Louisiana, up until the pandemic, did not have any provision for virtual meetings. However, realizing safety and public health, then in Louisiana developed at a statute called RS 42 17.1 a provision for virtual meetings. Here are the questions that we get. When can I have a virtual meeting? You can have a virtual meeting only if the governor has declared a gubernatorial emergency. It's different than emergencies that might be declared in your town or your village. Governor declared gubernatorial emergency. The gubernatorial emergency means you can't get a quorum there. You can't get a physical quorum. So what do I have to do? The head of the body has to certify with the agenda, and you can find this in our FAQs, which are on our website at lla.la.gov, a template for your certification. So the head certifies, because of the gubernatorial emergency, we can't get a physical quorum. So we have people participating. We also have to provide in that for how the public is going to participate. And we have to post that agenda. So the only thing that's changing now is the certification that goes with it, that's explaining why you have to do this meeting this way. And generally at the beginning of COVID, people were having emergency meetings like this because they had to pass the budget or they had to pay a vendor. Pretty much now, the way the law is written, you can have a virtual meeting as long as the governor is certifying. That's the criteria. And certifying an emergency, declaring an emergency, and the head certifies the emergency. So I hope that's very clear for you. Now, here's the complication that I know many of you have faced because I've taken the call. Jenifer, everybody can come. That we have a quorum. People are healthy, thank God. But Mr. So-and-so, he can't come. Can he participate in the meeting? He's an alderman. He can participate in the meeting like any other member of the public, but he cannot vote. So he can participate, cannot vote. Another problem that we have seen, not providing for the public to be able to participate. You don't want to mess up on that. You want to make sure that the public knows if you want to participate in this meeting, you got to go to this site at this time, or go to another building where there's a LinkedIn kind of streaming to the council. So those are the major issues on open meetings. Let me check now. I'm going to check and see if I have any questions. I see that I have a few, and they're written really small, so if you see me coming towards you on your screen, I'm not coming in to get my cup of coffee with you. Let's see. We have a question. Does a vendor demonstration have to be in open meeting? This is for our professional service, RFP, during selection committee. The committee, that's a really good question. I'm going to start at the end. The committee, if it's a committee of the board, has to follow the same public meetings laws as the whole board. So it's not so much a question that they're presenting an RFP, but is it a committee of the board? Committee of the board has to follow all of the public meetings rules and laws. And that could be like the finance committee, the executive committee, or this RFP selection committee. Another question, let's see. The agenda is controlled by the parish president or the chairman of the parish council, by the parish president. He is the head of the agency, so that's who controls the agenda. Now, let me say, you don't want to start World War III on an agenda. It's even though the parish president controls the agenda, I mean, really, everybody ought to be talking. Everybody ought to be talking. Now, not talking to the point where you have a walking quorum and you have another meeting outside of the lights being on. But, I don't think we should have dictators doing the agenda. Is it advisable or inadvisable to limit the amount of time for public comments in an open meeting? Well, since our days are finite, I think it's reasonable to limit the time, but you don't want to say, I cannot stand Jenifer, so I'm giving her 30 seconds, but I'm crazy about Lizzie, so she can talk 30 minutes. It should be a reasonable time so that you can have a reasonable meeting of the public body. Should the policies be part of the bylaws? I think that's a good idea. I think that's a very good idea. Is it mandated? No, but I think it's a very good idea. Let's see. Okay. Can the non-voting parish president participate virtually in a meeting that is not being held under a certificate-approved meeting? It depends if you have, if you allow the public to participate virtually. If he's a member of the public and he wants to participate virtually, I don't see any problem with that. That's not the reason for certification. The reason for certification is because you can't get a quorum there. Are we still under the governor's declaration for COVID? We are. We are under that. Under the Home Rule Charter form of government, does the parish president control the agenda if it's a meeting of the parish council? I can't answer that today, but you can call me. I can't answer it without reading your Home Rule Charter. Who's the presiding officer in committee meetings or council meetings? Depends on how you rule, how you state it in your policies and your ordinances. If you want to talk about particular issues, then you let me know. You call me. My number is 225-339-3871. If you record or listen or live stream a public meeting, do you still have to post the minutes from the meeting? Yes, ma'am. Yes. Whoever's asking that, yes, absolutely. Now, the Attorney General has said you can post a summary, but that does not relieve your responsibility to do that. If you have a virtual meeting, is the agenda still limited only to timely or emerging items or emergency items? I think it's expanded somewhat to whatever the leader of the public entity thinks is important. But I certainly think that timely and emergency items have to be there, but I think they've given you a lot more latitude since the last legislative session. In a regular public meeting, not virtual, do you have to give the public a way to call in also? That's up to your policy, or that is your policy. The way things are changing in our world, you may want to consider adding that to your policy. Now, I'm going to stop. I know there's some more questions because I don't want to have it, where I can't answer questions on other issues. So if I didn't get to your question, I want you to call me at 225-339-3871. Now, let's talk about public records. And I know you're going to have questions on that, and I'm going to tell you, let me get to it. I think it won't move because the little chart is still up.
Click on your screen.
There you go. There you go. Public records. Everything, think of this. Virtually everything that you do is a public record in your job. Everything you do is a public record. It doesn't matter what form it comes in. And it's a constitutional right in Louisiana, coming from the Napoleonic Code, that people have a right to review public records, except those that are specifically exempt by statute. So here's the public records, no matter what form. Now, here's the issues. Are they available? Here's my rule. And my rule is not just Jenifer Schaye's rule. It comes from reading the AG opinions, looking at the court cases. My rule is, if I have that public record within 3 days, as per the statute, I'm giving up that record. Okay? You will not ever succeed in, I say this ever, never is a long way time. It's virtually impossible for people to succeed in court if they don't give up a record that's not an exempt public record. Now, you say, well, I don't have the record. We don't keep it. Well, if you don't keep it, then within 3 days, you tell the person who's requested the record, I don't have it. We don't keep it. Or we don't keep it in the form you asked for it, but here's what I have. Also, with public records, they don't have to be requests. They don't have to be in writing. A person can come in your office. A person can come in the auditor's office today and say, please give me a list of all your employees. Will we have to give it? Yes. If they add to that request, They're standing at the front desk and they add to that request, and please give me all of their social security numbers. No, I don't have to give up that because that's personal identifiable information. Please tell me how much all of your employees make. Do I have to give that up? Payroll? Then what we were saying is yes, but do you get to know what my insurance is? No. What my deductibles are? No. But my salary? Yes. So on public records, we want to make sure that we understand that the record is the record of the public, and it is to be given up unless there is some kind of exemption. Now you say, and I've had this happen, I've heard it, I haven't had it happen to us, but how long do I have to retain that record? Well, if there's nothing specific in the statute, you have to retain that record for at least 3 years. You say, hey, look, we had a guy here who was heading up this place, and he wanted to keep everything for 20 years. Well, guess what? If somebody comes and asks for a record from the year 2000 or 2001 and you kept all those records, you're going to have to produce that. It's going to be expensive. You say, well, they got to pay for it. Reasonable cost is what the law says about that. But here's what's going to happen. It's going to take you so much time and money to produce all of that. You don't want that. If you tell somebody that you're going to produce the record, you tell them that within 3 days, then you can give it to them a week later or 2 weeks later, something reasonable. Records retention, back to that, is incredibly important. I urge you to develop a records retention policy, to work that out with the folks at the Secretary of State. They have some good information on their website and can greatly assist you in that. So let me look and see now if y'all have asked. I imagine you might have asked me a question on public records. Let's see. Are texting messages during council meetings considered public record when the texts deal with agenda items? Yes. As a matter of fact, that's a great question. If you have a phone and you have business stuff on the phone, even if it's your personal phone, the requester can get it. The problem, to go back to open meetings, the problem with texting during a public meeting, it can look like a walking quorum, and you really want to be careful with that. But let me just speak to texting in general. I say this to the auditor's staff about 2 or 3 times a year, and I've been here about 22 years. So I've said it about 50 times, and maybe I didn't say it in the beginning. Be careful in what you text. Be careful in what you text. You text that Jenifer Schaye is horrible. I think Jenifer Schaye is horrible. I cannot stand that woman. Guess what? You have created a public record, and I can get that record. Might be truthful as it can be, but I can get that record. That might be extremely embarrassing for your agency and for you. Public records is part of an information request. Citizens sometimes ask for copies of our computer reports for complaints and emergencies. This would include the names and phone numbers of the caller who are sometimes the victims of crime. Can we redact the caller's information? You can redact anything that's considered personal identifiable information. But again, I would have policies and procedures for all of that. Are we required to go back and watch years worth of meetings to produce all meetings which contain discussion of X topics. I mean, you can object and say this is an unreasonable request and it will take you so long and so much money, but that's why records retention is important, so that you don't keep meetings until from the beginning of time. Are scanned documents saved digitally sufficient for most records keeping? Yes, yes. It doesn't have to be paper. The law says you produce it in whatever form you keep it. If someone requests records from a police officer program to increase patrol total additional salary per officer, do we have to give copies of checks or just total amounts? You don't have to give copies of checks, but if they ask for anything that has to do with the security, you don't have to give that up. That's exempt. But if they want to know what is the salary of Patrolman X, you probably have to give that up. If you have a board member who habitually does not attend meetings but expects access to the audio the next day after a meeting, is this abuse of public records access? I can't really answer that because I don't know how hard is it to get that audio to that person. It seems to me the person would have a bigger problem if they're habitually absent from meetings, and that might be something the board wants to take up. Can the public get records of who's delinquent on their utility bills? I think that would be personal identifiable information. Is camera footage public record? Unless it has PII information. For instance, if you film your meetings, I think that is public record. If your phone does not retain text for 3 years, what is your responsibility under the records retention law? Well, if you don't have it, you don't have it. But I think most people and most companies can get that information. I don't think that's that hard for the cellular companies to produce. I know, again, I didn't get to everybody's. If you have some additional questions, you'll either call me or we'll answer them later on that. So let's go to the next topic, which is the Local Government Budget Act. Okay, hold on a minute. I got it. Okay, the Local Government Budget Act, we've talked about a lot at various times in these presentations. I think the main thing we need to talk about today, and Mr. Wagesback yesterday in his introduction talked about it, is that in every dollar you get in the town, in the district, whatever entity you are, has to be budgeted if it's part of the general fund or a special revenue fund. Has to be budgeted. And what we're seeing is because there's more dollars, there's more things to talk about, and people are in conflict. You really got to really work through that as a group. Because, for instance, the American Rescue Plan says you can do lots of infrastructure work. And Angela will talk about lost revenue, and that's going to give you some additional dollars to spend. And the whole concept, not additional, but how you record those. But everything that you're spending with this additional money, this town gets $10 million extra. Can I go and put it off someplace and don't budget it? Answer, no. When I budget it, I have to decide what I can use it for, because ultimately that'll get reported. But the main thing with the Local Government Budget Act is that you're able to arrive at decisions, do your budgets timely. Because if you don't, then what do we have? We have situations, and we have several this month, where towns are coming to their 6 months, 3 months or more behind in the budgeting. And what's happened is the law says you can only spend 50% of your last appropriated budget. Say, oh my gosh, the last appropriated budget said I had $100 for payroll. I just spent 50, but they got to get paid this week. Guess what? You don't have the legal authority to pay them. Got to pay, you're going to have an emergency meeting and try to figure this out. But don't let yourself get to those points. I think you're much better off if you can decide what you're doing and talk about it in a very forthright manner. Our budgets in Louisiana, revenues have to equal expenditures. Let me see if you have a few questions on that. Get to it. The Local Government Budget Act said, give me your telephone number again. Okay, 225-339-3871.
It's also in the chat. I posted in the chat.
Okay, thank you. So the Home Rule Charter, does it trump the Local Government Budget Act? Yes, it does. Yes, it does, in regard to what needs to be done. But if the Home Rule Charter doesn't mention a certain provision, then the Local Government Budget Act is what you follow. So it calls for financial planning and real consideration. To me, the Local Government Budget Act is where government has to be most mature and be in the best mode possible for listening and speaking. Okay. All right, let's go on to fiduciary. I've spoke about this a lot yesterday, so I'm not going to spend too much time. Not because I don't think it's important. I think it's the bedrock of what we do, that fiduciary responsibilities. But here's the questions we get under this category most is, do I get, let me just put it in the plain English to you, do I get a perk because I'm the mayor? Do I get a perk because I'm the councilman? Actually, no. If you have to spend money on a trip, then you have to be responsible to report that, to get reimbursement, but not to say, well, I'm going to bring my significant other on the trip, so pay for that person and I'll pay you in 6 months. That's a loan. That's a loan and not permitted by Article 7, Section 14 of the Constitution. So fiduciary responsibility is most where you're saying I'm transparent and accountable in what I get paid and in how I use the property. Can I bring the town's backhoe to my property to do some cleaning up? Now, trust me, I don't even know how to use a backhoe. I hardly know what they look like. But I know people like to bring heavy equipment at times to their own personal property. If it doesn't have a public purpose, your fiduciary responsibility would say, no, I can't do that. Suppose I have a vehicle. The town gives me a vehicle to use, or the district gives me a vehicle to use. What is my responsibility? It's to use it for the public purpose. Attorney General says incidental things can happen with that car. You can stop and get milk at the 7-Eleven or whatever you're doing, Circle K. That's okay on the way home. But can I take that vehicle on a family vacation? No. Even if I'm law enforcement, there's restrictions on how I can use that vehicle. So I think that those of you who are clerks, town clerks, those of you who are paying the bills in the town, sometimes it's passing your desk that a public official appears to not be doing this properly. I urge you to have courage. I urge you to talk among yourselves about how you can do this right. Best is to have good policies and good forms. When I go to the midwinter meeting, if you go to the midwinter meeting of LMA, is that a good purpose for public officials? Sure. Should you be reimbursed? Probably. But you should be reimbursed in a reasonable, expedited fashion, and everybody gets treated the same. Okay, so let's see if we got any questions on that. Are you allowed to charge your personal expenses to a government credit card and repay with payroll deductions in the future? I would say no, no, no. Is that clear? No, no, no. That's an abuse. That, to me, from the question itself, appears to be an abuse. And I urge you to not let that happen. I urge you to use credit cards, even the government credit card, in a very, very restrained fashion. You don't want to see, and our auditors see it, you don't want to see on the credit card that there were purchases at Walmart for things that are obviously personal expenses. Nobody gets a pass on that. Okay. All right. Now, our next topic is the audit law. And our most questions that we get on the audit law is, when do I have to report that something's gone awry? And that's notification to the auditor, RS 24523. And what we're talking about there, let me get it straight for you, is when you have a reasonable cause to believe that something occurred that where you lost assets. You say, man, I did everything right, but she still stole the computers. Well, you're not going to go to jail for that. What's going to happen, though, is you're going to report by statute. You're going to report that to the auditor and to the district attorney. And why do we want you to do that? Because we want you to do it at the beginning, when you know that's happened, not a year from now, not after you talk to her 30 times and asked her to bring it back. No. When you have a reasonable cause to believe there's been a misappropriation, not only of money, but any assets of the agency, then you'll notify the auditor in writing and the district attorney. I mean, it's a fairly straightforward thing, but people really don't want to do that because usually these kinds of things occur with the person you eat lunch with. You know, it just happens. People get confused about what's important in life, or maybe you didn't realize this person had a hidden addiction to gambling or drugs or whatever. That person needs help, but that's not your job at this point. Your job first is to report, and then it'll have to be worked through the system. On the other part, what I don't see too many people having a problem with this, but it's because the CPAs keep it straight, is that the audit law tells you when you have to report and what you report on. If your entity has less than 75,000 and under in revenues, you're only going to give us a sworn financial statement. 75,000 and 199,000, you're going to have a compilation, and then you have 2 attest times. Attesting by an independent CPA when there's $200,000 to $499,000 in revenue, or a full-blown audit when it's more than $500,000 and over. You say, well, that's the numbers. You know the numbers. Here's where I think we get the things go off the track. People don't engage the CPAs timely, or they don't cooperate with the CPAs. Well, what comes after the audit law is that if you don't comply with the audit law, you're going to get on what we call a non-compliant list, and that's going to stop the flow of funds to your town or your particular subdivision. That law is 3972.1. So you're going to make sure that you're in a situation where you're not having that happen to you. Anytime you have a problem where you don't know, hey, should I really tell the auditor about this? Call us up. Talk to Diane Allison. Talk to Jenifer Schaye. Talk to Angela Heath or Patrick Virgadamo. Let us talk to you about it. We have lots of experience. We've heard, it's kind of like, sometimes I feel like when I was a kid, I hated to go to confession. I mean, I really hated it because I thought I had a sin no one else had. Trust me, when you notify the auditor of something happening in your town, we've probably heard it. And we don't make a judgment. We just want to tell you how to report that and let the system of government work. So I urge you to look at that and to think about that and to keep everything straight with your reporting requirements. Now the next topic, maybe I have a question or two on this. Let me see. Are port authorities that collect tariffs considered auditees? Yes, I think most port authorities might want to call me individually, but most port authorities are considered local government entities. What about when annual inventory has some missing assets that may not be the result of misappropriation, but just not sure of location within the agency? Is this reportable? You have to make a decision on that. Sort of sounds like misappropriation to me, but you have to make that call, whether it's misappropriation or just simply, I hate to say this, but carelessness or misuse of public funds. A lot of times the auditor is going to report that you don't have a good system of inventory. It's not your house. It's public. It's public property. You have an obligation to keep track. So it depends what the situation is. At the time of Katrina, millions and millions of dollars of equipment was lost from various state agencies where the hurricanes hit worse. And, we couldn't just say, hey, they misplaced that. It was really looked like a lot of it walked out the door. It was an opportunity, and there were people with black hats who took it. That got reported at under 24523. Okay. All right. We have 3 more topics. Cooperative endeavor agreements. I put this here, and we have a form on our website, but I put this in because we get lots of questions about how do you create a cooperative endeavor agreement. Or we get someone saying, oh, I had a cooperative endeavor agreement. Angela and I shook hands. It's public property. It's public money. I suggest to you, although it's not mandated, that any cooperative endeavor agreement where you're going to transfer funds of your agency to another agency, I suggest to you, you want to have a written agreement. And that written agreement ought to say, this is part of my public purpose, following Cabela, that case we talk about with you a lot. This is part of my public purpose at this entity's public purpose. It's not gratuitous, and it's going to benefit this agency. Now, there's sometimes when you can just move the property. If you're law enforcement, you're moving it from one to the other. That's allowed, and that's in Article 7, Section 14 in the Constitution. And there are instances, but more than that, we see where people want to work together to work on something. Let me get, like an example would be the library. They want to build a new library, and it's going to be paid for partly by the library board and partly by the parish. There ought to be a cooperative endeavor agreement that says between them who's doing what, and everybody is reviewing it before $1 is transferred. Think about cooperative endeavor agreements the way you think about contracts. I promise to do this because it's part of my purpose. It's not just for one purpose, one person, and it's going to bring about a public good. So think about it that way, and you won't have any problem doing it correctly. Let me see. Got one question on this. The budget must have revenues equal to expenditures. Oh, this is a budget question. Or can transfers in and transfers out plus revenue equal expenditure? You're looking at the budget as a whole. You're not looking at like segments of time. Looking at the budget as a whole. After you've had the transfer in, transfer out, revenues equal expenditures. That's your question. That's your answer. Okay. Now, let's go to, this is a topic that nobody wants to talk about. It's a little bit more in CEAs. Fiscal administration. What is fiscal administration? It's when the Attorney General, the Treasurer of the state, and the Legislative Auditor have determined that a particular village, town, city is not fiscally stable. They're unable to pay their bills. They have issues that are, the best way I can say it to you is they look like they're going to go bankrupt. We don't want that to happen. We want people to be safe. Good water, good sewer, good functioning of government. So if it's so unstable, and you see the definition of fiscal stability, then that committee of people, Attorney General, Auditor, Treasurer, on the recommendation of the Auditor, consider whether we should have a fiscal administrator in this town. If we should, then they make that recommendation, and the Attorney General files suit in the court in that particular jurisdiction. The power of the fiscal administrator is significant. The fiscal administrator comes in and virtually sets aside the decision making of the chief officer, mayor, and the board of aldermen or council. Now you say, whoa, can they do that? Yep. We have some very significant statutes that allow that to happen. So they're telling me I only have 5 more minutes and I have one more topic. So I'm going to look at the questions on no questions on that. Okay. All right, then let's go to the final topic, and that is surplus property. And the main thing I want to talk about on surplus property is, unlike what you might do at your house, or you put it in the recycle bin as soon as you think it's something that you can't use. You can't do that with public property. You have to have a resolution that says this is really surplus property. We're not using it anymore. We put it out for auction, or we do it on our website so that other people can use it. I can, in certain instances, share it with another political entity. Here's what I see as a major problem with surplus property. People want to trade in. You can't do trade-ins. That's not allowed under the public bid law. It's not allowed under the surplus property law. So with surplus property, what you're doing is declaring it surplus, try to sell it. If you can't sell it, then what I'm going to do then is declare that it's scrap, and then I can get rid of it. Major issue also in surplus property is, can people buy it who work for the town or work for that agency? Answer, no. That would be a problem. So you put it out. It's kind of like the reverse of public bid. I'm not pulling it in. But everything in the surplus property statutes indicate has to be notice, has to be arm's length transactions, and fully documented. So I'm like 2 minutes from my time. Let's see, is there a question here? Yeah, there's one. When a contractor is used to auction surplus property, can the public body require a list of those who purchased the property at auction? Sure. No, it's your property. It's your property. Absolutely, you can. Can it be donated to a nonprofit? It depends if you can meet the Cabela test. And that Cabela is, it serves your benefit, and it's not gratuitous, and it will turn to something better for the it's part of your public purpose. It's not gratuitous, and you hope to get something in return. But you can't what I've seen sometimes is people want to buy something extra so that they can give it to a nonprofit. Can't do that. That would not be appropriate. Do you have a surplus property sale document for advertisement? Yes. We, if you're asking, we detail it out in our FAQs on surplus property. I hope that I've helped you somewhat. I've done it at a 30,000 foot. Let me see. Angela's telling me. Oh, yeah. There's a question that they changed in the law. Police dogs. Now the canine handler can. That's one place where you can buy the property you work with. And that's a canine handler can buy the dog. That's a good thing for all of us who care about dogs. There's also special rules for how you dispose of guns if you're a sheriff's office or a police department. There's some very specific rules on that. Bottom line, it's supposed to really be surplus, not just something you decide you're going to give to one of your employees as a bonus. I always enjoy doing these. I learn more than I teach. I'm happy to help you. So are all the people in the auditor's office. That we give you the information that you need and help you to move forward. I know your situations are sometimes very particular, and we work through those. We post those questions that we think are most universal on our website, and it's a fully searchable document. But we also urge you to keep up with, and we try to help you keep up with, Attorney General opinions and the statutes as they change. We will, in the fall, Diane mentioned this, hopefully we'll be doing another one of these after the legislative session, and we try to update our presentations at that time. So I wish you all a very good day. I thank you for your service to our state, and I look forward to talking with you again. Take care.